My name's Esther. I'm the director, one of the directors of Seed HR, along with my business partner Christy and a team of 5. And a special welcome to our newest team member today, Jersha, who's based in the Philippines. Welcome, Jersha. Hope you enjoy. And as I said, we've created this series to equip business owners with super practical tools for success. I think I've gone through most of the housekeeping. Yes. So I'm going to introduce Brigid. She is a partner with Addisons. Brigid and I have known each other a number of years from when I was in corporate HR land. And what I love about Brigid is she is super practical and tailors her advice, which is what we are all about as well at Seed HR. I love this quote from Brigid. Employees are a company's most valuable asset. I work with my clients on all aspects of the employment relationship and provide practical advice for organizations to proactively manage workplace risks before they arise. Ideally, prevention is better than cure, but if you're in a mess, Brigid's also useful. So Brigid specializes in all aspects of employment, safety, and industrial law. She's a former work health and safety prosecutor and brings her unique expertise to safety, compliance, governance, and also advises clients on the intersection between safety, employment, and industrial issues. She's got significant expertise in employment advisory, employment disputes, discrimination law, and workplace investigations. And as I said, she's got a broad range of sector experience, and we love her because she also understands small business as well as big business. So without further ado, I will hand over to Brigid. Brigid, just give me a nod when we want me to change your slides. And as I said, if you have questions, feel free to ask or pop them in the chat.
Thanks so much, Esther, and hi everyone. Thanks so much for joining us today, and thanks for that great introduction, Esther. It's been great watching Seed HR go from strength to strength as well over the last few years, so it's wonderful to be here today. As Esther said, please feel free to pop a comment on the chat. Take yourself off mute if you feel like, if you want to ask a question along the way, but there will be some time at the end as well. So the purpose of today is really just to give you a little bit of a overview of some of the key cases and some developments we've seen in the employment law and industrial law and safety space over the last year or so, and what we can expect going into 2026 now that we're only just over a month out from Christmas, which is a little scary. Esther, if you can go to the next slide. So the first thing we're going to talk about is, and you might have seen this in the news, a big recent proceedings in the Federal Court of Australia involving Woolworths Group and Coles relating to some claims for underpayment. So, and you might be thinking, why are we talking about these big businesses? I'm from a small business. How does this relate to me? Well, I'll tell you a little bit more. Esther, if you can go to the next slide. So just a bit of quick context about this decision, because it really is quite a shift in a certain area that in terms of what people have been doing in this space. So this basically related to a case where back in 2021, the Fair Work Ombudsman commenced separate legal proceedings against Woolworths and Coles in relation to some alleged underpayments of some of their salaried employees. So specifically some of the managers in their retail stores, and then concurrently some employees from both of those organisations commenced class action proceedings against the companies, and the matters for efficiency were heard together. So basically the proceedings considered whether Woolworths and Coles had failed to ensure that the annualised salaries paid to managers were sufficient to cover their award entitlements for all hours worked, taking into account overtime, weekend and public holiday rates, allowances and so forth under the General Retail Industry Award. So these were award covered staff, and basically what the court looked at, it basically looked at, whether these annual salaries were sufficient. It looked at record keeping practices, and Esther, if you can go to the next slide. Thank you. So basically, I mean, and I won't go through all of the decision. It is a complex decision, and there's a lot of reading to do. But basically, what the court looked at was trying to calculate what these people were paid in terms of their annual salary, what versus what they should have been paid under the award. So they looked at, and both Coles and Woolworths argued that they had what are known as set-off clauses in their employment contracts. So basically said that we pay an annual salary to set off any payments that you would otherwise be entitled to under the award. We pay above that, and so we don't have to calculate and pay you hourly. We pay you an annual rate. And they relied on a lot of their timekeeping records. I had to go back and look at, I think, around 28,000 employee records. But they relied on the rosters of those employees and also the clock in and clock out times for the purposes of their record keeping obligations under the Fair Work legislation. So there are, as you probably know, employers have quite stringent duties under the Fair Work legislation to keep pay slips and employee records for a period of 7 years. Now, not only do you have to obviously record what the employing name is, what their person is paid, the gross amount paid, the net amount paid, any deductions. You also have to record any penalty rates or loadings that are paid for overtime worked. And this is one of the issues that came up in these proceedings. So effectively, the employers were looking back at the records and just looking at those clock in time. It didn't specify the number of overtime hours worked on each particular day in their pay slip. And so while the court looked at this and said that even if the number of daily overtime hours worked by an employee as well as the start and finish time could be deduced from those clock in, clock out records, it did not constitute a sufficient record to meet the requirements of the Fair Work legislation because the data should be, number one, it has to be easily accessible by the employees. It has to be easily accessible by a Fair Work inspector if they want to come and inspect those records. And it has to clearly outline the specifics of the relevant modern award entitlements, including overtime hours worked and the basis for the calculation. So basically, in other words, what they found was that just presenting raw data that needed to be, in the terms of the clock in, clock out time, that needed to be analysed or interpreted to obtain the information was not sufficient to meet the record keeping obligations under the Act. So basically, they looked at that, and so that's probably, I guess, a big thing in the sense that a lot of organizations do pay annualized salaries, and don't necessarily, you might have a roster, you might have records of people's working hours, but you might not keep physical timesheets which say, they worked 20 minutes overtime or whatever it might be, and that's not necessarily recorded in a pay slip or somewhere else in a record. So they had to go back to those sort of clock in, clock out times, and so that was not sufficient. The court also looked at the contractual set-off clauses in the employment contracts. So again, that clause that you might have in one of your contracts that says we pay an annualized salary to cover any entitlements that you might otherwise be entitled to discharge any obligations under the award, such as overtime. And the court found that in this situation, the contractual set-off agreements in these particular contracts were only effective to discharge the obligations within a single pay period. Now, historically, there's been a sort of view that you might overpay in one pay period and underpay in another, but if you looked at it on an annualized basis over a 12-month period, that would be okay. And the court said that in this particular case, that was not okay. So if we can just go to the next slide, Esther. So in terms of the actual set-off clauses, as I said, they were only effective to discharge the obligations in one single pay period, not in a 12-month period. So what does that mean for everyone here? Well, first of all, this is a decision, obviously, that related to employees under the General Retail Industry Award. So different modern awards, and I know there's lots of you from different industries here. Some of you will have people covered by an award, some might not be covered by an award. But for those who do have staff that are award covered, you'd have to check the award entitlement. Some awards do have provisions that say, for example, if you pay a person 25%, an annualized salary, and that annualized salary is, say, like 25% higher than the minimum rate under the award, you can make an agreement with that employee about, paying them that 25% more to offset other award entitlements such as overtime and so forth. So there are certain rules in certain awards that will allow you to still have an annualized salary arrangement. The General Retail Industry Award, which was considered in this decision, doesn't have an annualized salary clause, so that's relevant. But I guess, the key point here for everybody is that you need to consider, if you are relying on annualized salary arrangements for staff that are covered by a modern award, do you have a contract that has a set off clause, and is it fit for purpose? Because, as I said, in this particular case, it was said that, that set off clause is only effective for one pay period. So say you have, you might overpay someone because you're paying an annual salary. So every month they get paid the same amount. 1 month, if you looked at all the hours worked, they were overpaid against the award by quite sufficient amount. But then you might go to a really busy period, like coming into the Christmas period, and they're working extra hours, and in that month or whatever the pay period might be, they actually were worse off than they would have been if you were paid them hourly for each hour under the award, including looking at the overtime or penalty rates that apply. So for those of you particularly who have employees in, if you're working particularly in retail or some franchise businesses, or you're in manufacturing, warehousing, and those sorts of businesses. But even if all you've got employees working odd hours, you've got shift workers, you've got to think about all of these things. So really, and also you really need to think about your record keeping. So I know some of you might use timesheets. Or you might have, you might think you rely on a roster. I guess think about those things, because you need to sort of review your systems and processes to ensure that people are getting paid. If they're on an annualized salary, they are getting paid what they're entitled to in each pay period, or if you've got arrangements about annual salaries, that they comply with the relevant award. So really, it's been a big shift, I suppose, in the sense that a lot of people do have these obligations, like in set off clauses in their contracts, and they're not necessarily fit for purpose. And just having like a template set off clause in one particular industry might not work for another. So also thinking about if you if you have a template that you've got from somewhere, making sure that it's fit for purpose for your specific business and for your workforce if they're covered by an award, because as I said, some awards do have annualized salary provisions that you can have obligations like this, and some don't, and obviously some of your workforces may not be award covered. In that case, you can have normal annualized salary arrangements. So really just talking about the type of businesses that have award covered employees. So at the moment, this is the status quo. We're not sure if Woolworths and Coles are going to appeal. Might happen, but at the moment, this is what we're left with, this federal court decision. So someone's just asked a question: is an annualized salary the same as an annual salary? Yes, I'm annualized, annual, same thing. So paying someone for a full year, like saying, you get 60,000 per annum, as opposed to if you're paying people by the hour. So here we're talking really about permanent full-time or part-time staff, as opposed to casuals who are paid an hourly rate, just to be clear. Did anyone have any other questions before I move on about what they should be thinking about, or what they should be doing in light of this decision? No? Okay. Well, yeah, it's as I said, it's received a lot of airtime. So I think, again, just to be checking what you're doing in terms of time recording, if you are paying annual salaries for award covered staff, and just having a look at your contracts and getting some good advice around those. There's a question I think that's just come in. I'm just checking. Are bonuses considered, or are they considered on top of annualized salary? The bonuses, generally a bonus is a discretionary benefit. It depends. Yeah, so we're talking here about wages and amounts for people covered by a modern award in terms of what they're paid for all hours work. So having regard to penalty rates, overtime if they work overtime, all those things. And there again, those analysis are they're very specific on the industry and the award that covers the relevant employee. Bonuses are usually a discretionary on top of salary. We're not talking about bonuses in these kinds of things. So this is usually just about what people are paid for the work and the hours that they do. Now, having seen, this case is an example, but no matter whether you're the biggest business in the land, like Woolworths is one of the employees, probably one of the most, highest number of employees in Australia, of any business in Australia, whether you're Woolworths or you're a small business owner, these things are complex, and you can see from, if Woolworths and Coles can get it wrong, anyone can get it wrong. And so I think the other thing is to consider, if you're a smaller business and you need some flexibility, can you enter in an individual flexibility agreement where the award allows you to do that with an employee? And that can vary, say, for example, the span of ordinary hours under an award that's a bit more specific to your business, or if a person requests a particular, arrangement. But again, make sure you get some advice around those. I've actually, in the last few weeks alone, been advising two different businesses. One is a small business, one is a very large business. And both of them have had advice on individual flexibility agreements that seek to amend, terms and conditions for an employee or a group of employees with regard to the award. That has implications for things like payment of overtime and those sorts of things. And they've both been wrong. And that's not great, because then they have to go back and terminate those, redraft them, etc. Now, in one case, I think they just got poor advice. The other one, they actually did get advice from a fairly specialized area provider. But even so, I think just making sure you're getting advice around those is really important, because
couple of questions, Brigid. Someone uses Xero and MYOB to keep track of pay slips. If moving from Xero to MYOB and Counsel, the Xero may lose access to all the old data. How do I know what I have to download before I cancel the old accounting subscription?
That's a really good question. And I have had businesses that have had this issue where they've lost access to those records. So you need to figure out with the provider, somehow you have to keep a record of those, whether it's on an physical or external hard drive, and you have to make sure you've got those records. So that's your obligation as an employer to keep them. So I don't know the ins and outs of MYOB and Xero to be able to say how you do that, but you definitely have to keep records. So I'm not sure who you ask. I don't know if you've come across that, Esther, but you need to keep those records for 7 years.
For example, if changing payroll providers, I know that the current provider can provide you with a download of all your data and before you switch to the new. So I imagine Xero would do the same. I haven't asked, though, the question specifically from Xero. So it might be something to ask your Xero person or your accountant. Where do we need to specify modern award entitlements? Is it on each pay slip, as in if they're getting penalty rates over time, that kind of stuff?
I mean, that's the obvious place to record them. Now, I know a lot of people don't always do that or don't have that. The record keeping obligations and what the court looked at in this case didn't say where. It just has to be readily accessible to the employee. So a pay slip is an obvious place. But yeah, there's no sort of hard and fast rule about where it has to be kept, as long as it's accessible to the employee, and it does specify. So for example, if they worked X amount of overtime in a particular pay period, like you'd record the amount of hours of overtime in that pay period and all the penalty rates that are applied in that pay period, for example. All right, just mindful of the time, we'll move on. The next case, and again, I won't go too far into the detail, but I think it's a really important one that, again, this is a recent case from the High Court of Australia, and it looked at the obligations of an employer to redeploy somebody in cases of redundancy. Now, obviously, small businesses are unlikely to go through large scale redundancies, obviously, but obviously being a small business, sometimes you have to be very nimble and redundancies do arise. So I thought it'd be just helpful to go over what a redundancy is at law, because I know Esther sometimes says this, I say this, like people sometimes come for advice and they say, oh, I could just, this person's not really performing, but we could just make them redundant. And they love to sort of just sort of go, well, it's an easy way out, to get rid of somebody they don't want in the business. If we could just pop to the next slide, Esther. So um, within the Fair Work Act, a person that and these provisions relate to when someone has a right to bring an unfair dismissal claim and whether they can say it wasn't a general redundancy effectively. But basically, a genuine redundancy is where an employer no longer needs somebody to perform that role any longer. So it's genuine if you're not going to effectively replace that person's role with another person. I mean, it can be that, because people often say, is there a period in which I can't rehire the person? Could I just wait 6 months and rehire? Is that genuine? I mean, if you genuinely don't need the role at the time at which you made the person redundant effectively. Um, but but if it's also not going to be a case of genuine redundancy if it would have been reasonable for the person to be redeployed within the business or an associated entity of the employer. So even if you have less than 15 employees in your corporate entity, you might have associated entities overseas. You might be a subsidiary of a bigger business overseas. Technically, you still have to consider redeployment across those other businesses, those associated entities. And while small businesses who are people with less than 15 employees don't have to pay statutory redundancy payments on termination under the Fair Work Act, that doesn't mean you don't have to comply with the obligation to consider redeployment, even though I realise that in a small business, those opportunities may be quite limited because of the nature of the business size. So Esther, if you just go to the next slide. So this case, again, interesting because these kinds of cases don't often go all the way to the High Court. So this, as I said, it related to a big business, but the concept in terms of small business is similar in the sense that it related to a coal mine operated by Helensburgh Coal. So they were going through a large scale restructure. They didn't need as many workers. They went through consultation as they were required to do with the employees prior to making any final decision. And the feedback from those workers was that to reduce the impact of the redundancies on the employees, that they should get rid of some of the contractors they were using to engage at the mine. So basically, they got that feedback from the workers, and they said instead of relying so much on external contractors, you should get rid of some of those contractors and redeploy the employees to those roles performed by contractors. Effectively, they still proceeded with a restructure and reduced the workforce. So they engaged there were 90 employees ultimately made redundant, and 22 of the 90 brought unfair dismissal claims in the Fair Work Commission, saying that the dismissal was not a genuine redundancy. And their argument was that because the business could have insourced some of the work that was being performed by contractors at the mine, and then effectively the company appealed those decisions. The decision was upheld. Then they went to the federal court. Anyway, long story short, I won't bore you with the process. It ended up in the High Court. If we go to the next slide, Esther. And in the High Court, they were looking at that provision I said before. They were considering Section 389 of the Fair Work Act, which is the provision I talked about a few minutes ago. But it's basically they were looking at whether when the Fair Work Commission is tasked at looking at whether someone could have been redeployed in all the circumstances, whether the Fair Work Commission was permitted to consider whether the employer could have made changes to how it uses its workforce to operate its business. So when it's inquiring into whether it would have been reasonable in all of the circumstances to be redeployed, it was held that the Fair Work Commission could look at how the employer could have changed its workforce to operate. So in this case, obviously, the use of contractors was the key thing. So basically, it found that whether a person's whether an employer no longer requires the person's job to be performed because of changes in operational requirements is a factual inquiry, and redeployment does not require there to be a vacant position. Now, what that means is when you're making somebody redundant, you don't have to create a new role for them, obviously. That's not the requirement. There's a requirement of reasonableness, and if it would have been reasonable in all the circumstances for the person to be redeployed. So there doesn't the High Court held that you don't have to, there doesn't have to be a vacant position. It just looks at whether there is work, a demand for work within the enterprise or an associated entity's enterprise that could have been performed by the person's whose role was otherwise redundant. So when you're looking at what is reasonable, so yeah, looking at, as well as, again, in a small business, it may not be, it may be very clear that you just don't need the person anymore. The business needs to retract, but just think about it, I guess, in terms of that obligation more broadly. Is there a position? There might not be something readily available, but if you're relying on contractors and so forth, you have to think about the operational requirements and so forth. What are the qualifications? What are the person's skills? What's the location of the job, in terms of what's reasonable? So, I guess it's just a bit of a shift in thinking about the redeployment obligations under the Fair Work Act, and how the Fair Work Commission will be approaching these decisions moving forward. So just to keep in mind, if you do have redundancies, to be thinking about these things, and also, thinking about it in terms of, is it the case that I no longer require the role to be performed by anyone? If you're thinking, you need to get rid of someone for performance reasons, that's a different discussion to be having. Then I could just make them redundant if you're going to, need somebody to do the job after all. The other shift we've had before, we're going to talk a little bit more about redundancy while we're on the topic of redundancy. And this is a big one that some of you might have read about in the media too. Again, involving large scale redundancies in the university sector. But the reason I suppose this has been big news is because it's sort of the first time where a safety regulator has come in and actually stopped a large business from going ahead with its redundancy process. So this involves, basically in the last few months, Safe Work New South Wales issued prohibition notices to UTS and more recently to Macquarie University, who were both undergoing large-scale restructure processes. And they did that because they said that the process, there was a risk of imminent psychological harm from the way that the universities were going about the consultation and the restructure process. So basically, under the Work Health and Safety Act, a regulator can come in and issue a prohibition notice, which basically says you have to stop doing what you're doing until we're satisfied it's safe for you to continue. So the reason this was so big, as I said, is there's much greater focus by regulators on psychosocial hazards, but this is the first time it's really stopped a large organization from doing what it's wanting to do in terms of restructuring. So in the case of UTS, Safe Work basically argued that workers would be exposed to a serious and imminent risk of psychological harm from the actions taken and planned under the proposed initiative to restructure. And they felt that UTS was failing to manage these risks so far as reasonably practicable. In the case of Macquarie University, they were concerned about the consultation that was being undertaken with workers. And similarly, they were issued with a prohibition notice, which was later lifted, but obviously quite unique circumstances. I guess the point for small businesses is that it's just a shift, whether you're big or small. If you are making redundancies, whether it's one person, two person, and I think particularly in a small organization, if you are having to make redundancies, the impact on the person is probably far more obvious in the sense that it's a small place and there can be a huge impact on morale and so forth. But I guess, while you're not likely to be making large scale redundancies, you still have to be aware that there is an obligation to consult with your workforce so far as is reasonably practicable under the work health and safety laws. So while you might have to consult with workers under an award, if they're covered by an award, you have these consultation obligations under the industrial relations framework, but you may also have to consult workers about any work health and safety matter through the process available under the work health and safety laws. Now, what that means in practice is that the way you consult and how you consult might, how you do it in a small business is going to be very different to larger businesses. But what I often see in smaller businesses is they don't even consider consultation very much because there's no redeployment. They just think there's nothing, I'm just going to get rid of this person. There's no job available. I'm not going to consult with them at all. So I think it's just thinking about the way the process is run. And often, you'll see in large businesses, they'll have teams of people who are working through these large scale processes. There'll be multiple consultation meetings. There will be a very sort of structured approach. That's not going to be, reasonable in a smaller business, and that's not necessary. But I think the other thing I often see is that, in a small business, they don't always have the type of support available to their staff that are going through these changes, which is fair enough because, you don't have the type of revenue to be sort of going, oh, we have a employee assistance program available to us or something that we can use to help support our staff who might be impacted by redundancy. So I guess it's just about thinking outside the square about the support from a work health and safety perspective and, to manage psychosocial hazards in a redundancy process, what things you might be able to provide that are reasonably available to smaller businesses. So I've seen things like offering, a reimbursement up to a particular cap for, external counselling or psychological support. So you might say, I'll give you $1,000 if you provide an invoice, we'll reimburse that, that money incurred for counselling. We'll provide outplacement services up to a cap, or, there are lots of free mental health services available to workers as well. And I think that, having worked with large businesses, small businesses, and sometimes on the other side advising employees, it's such an important thing as to if you manage it well and people feel supported through a process, it's going to bode well for them. It's going to give them a better reflection on your business because it's inherently obviously a stressful thing for anyone to go through. So I guess that, the point of this is, while I don't know that SafeWork's going to be knocking on everyone's door in terms of small businesses, but they're certainly increasing, particularly in New South Wales, but we're seeing that sort of other regulators in other states, a huge focus on managing psychosocial hazards, a lot of union activity in this space as well. If any of you have if any of you have unionised workforces, certainly a large number of unions who are really pushing this. You might have seen, for example, in the news, like all the large scale proposed redundancy at ANZ, the finance sector union are really pushing on the stuff about psychosocial hazards, managing the risks in a redundancy. So it's really just thinking about these things that are topical and how to approach them in the smaller business context. And now we're just going to shift to the last little bit of the session. We're going to talk a little bit about some other recent changes and what we're looking like, what we might be expecting ahead in 2026. So the first one I'll just touch on really quickly. It was just a recent amendment made to the Fair Work Act and it was in relation to protecting penalty and overtime rates. So basically, this legislation doesn't create any new compliance obligations for employers, but beyond what's already in the Fair Work Act or any modern award that applies to your workforce. And it doesn't really impact your day-to-day workforce. But just if you just go to the next slide, basically it's just a provision about requiring the Fair Work Commission to ensure if they're making, varying or revoking provisions in modern awards that they can't reduce penalty rates or overtime rates. And they don't include terms substituting penalty rates or overtime rates to reduce the employee's remuneration. So as I said, it's not something that's going to impact anything at the moment. And for now, the existing provisions in modern awards, which allow for annualised wage arrangements, will remain effective. So as I was saying earlier, in the context of the Coles and Woolworths decision, if you have employees that are covered by an award and you have annualised arrangements compliant with that particular award, that will be fine and that will stay the same. But I guess it'll be interesting to see how this plays out next year. So basically, there's a case you might be aware of, or those of you who have sort of administrative staff in your business, which might be many of you. If we just flick over to the next slide, there's going to be a case heard in February next year, and there's been a little bit in the media about it. Probably not as high profile as some of the other cases we're talking about today, but there's basically going to be a case about some proposed provisions that are going to be put into the Clark's Private Sector Award. Now, that award, as I said, generally covers employees who, like, secretaries, PAs, people who are performing primarily administrative functions. So that covers a lot of employees and a lot of different businesses. And that proposal includes about making working from home arrangements more workable for people covered by that particular award. But there's been a lot of chatter around the proposals put forward by various unions, various work employer groups about how this is going to work in practice, how that provision I talked about a few minutes ago, how it will be impacted by this particular provision. So it's really just more of a watch this space if you do have employees employees that are covered by the Clark's Award. If you're not sure, obviously get some advice about whether you have employees covered by an award, because as I said, these things are quite complex and you obviously have to comply with different obligations depending on the provisions of the award. But I guess with this thing, the thing that we're seeing is we're sort of seeing a rehashing about issues about working from home. And that is, I think, because Victoria were proposing to make legislative changes about working from home for all staff. We've recently seen a case involving Westpac, which I'm going to talk about now quickly. So there's been a lot more chatter, even though I thought like working from home debate was over, COVID's over. Here we are back in 2025 and the working from home debate is hotter than ever. But I guess the point here is this case I'm going to talk about now was very much specific to the facts of this particular employee. And many of you might have generalized flexible work policies where you can say people can work remotely however many days a week, 2 days a week, or you might have more stringent policies that you want people to come back to the office. I want to just distinguish between those kinds of policies that are at a workplace level that can apply to anybody that role where they can perform work from home, their role lets them or allows them, or you have sort of a generalized policy, as opposed to the provisions in the Fair Work Act, which basically allows certain people who have at least 12 months service, so certain people who have rights to formally request flexible work arrangements. So if you're pregnant, you're a carer, you're a parent of a school-aged child or younger, you can actually request to work flexibly, and there are certain provisions in the Fair Work Act that you have to comply with if you have a particular request. Now, in this case, Ms. Chandler was a long-standing employee of Westpac, and she had previously, back in sort of COVID time, I think 2021, she relocated 80 kilometres southwest of Sydney to Wilton, just because her children were attending a private school near her family home. She was working remotely from home for some years. The bank introduced a hybrid working model, which basically said we want people to attend an office at least 2 days per week. Initially, she was told she could work 2 days per week from the Westpac Bowral branch. And then they reversed that and said, no, actually, you need to come to a corporate office, and the closest corporate office to her house, I think, was in Cogra. She basically said, no, I can't do that because I have to work, Cogra was 2 hours from her home and where her kids attended school. If we can go to the next slide, Esther. So she submitted a formal request. So this hybrid work policy was meant to apply to everybody. She submitted a formal request under the Fair Work Act to work full-time remotely, having said, she'd done it successfully for many years. And this request was rejected by Westpac, so the dispute then wasn't resolved. and then it went to the Fair Work Commission. So the Fair Work Commission looked at this, and as I said, it very much looked at her personal circumstances. And one of the things they did look at is that, the fact that, well, yes, she had a right to flexible work arrangements because of her carer's responsibilities. The fact that she had been working successfully for some years was also part of the decision. But just to be mindful of the decision, as I said, if someone makes a formal request, the request must be in writing and it must set out the reasons why they're seeking for their working arrangements to change. And the employer has to respond in writing within 21 days and can only refuse a request if they, on reasonable business grounds. And so in this case, the Fair Work decision basically ruled in favour of Miss Chandler and said they were quite critical of Westpac's failure to follow the statutory process for responding. You're meant to try and agree these. The reason these decisions don't often come, to the Fair Work Commission is because they're usually settled or they're usually resolved before they get to a dispute. Because obviously having a dispute with a current employee is never a good thing. And so the reasonable business grounds Westpac said were basically it would likely result in a significant loss of efficiency and productivity or have a significant negative impact on customer service. They thought that their hybrid work policy provided a measured approach that allowed for a mixture of in-person and remote work and effectively manage it across a large workforce. She, on the other hand, submitted that the team collaboration was unlikely to be adversely impacted. Face-to-face contact was not an ordinary part of her job, and her team had functioned well without in-person attendance for some time. So I guess the point is, again, you might have a broad policy, but people can still make requests if they're entitled to under the Fair Work Act. You have to try to resolve that at the workplace level and respond in writing in 21 days. I often see in small businesses that these sort of stringent requirements aren't always followed because it's a bit more relaxed. It's a small business. We can have conversations about it. But, if it ever goes pear-shaped and you haven't followed the stringent process under the Fair Work Act, it can, get you into trouble. So just having a broad brush approach to, well, everyone has to come in is not going to necessarily be, a reasonable business ground to refuse a request. It really has to be looked at on a case-by-case basis. Someone's asked if an employee is covered by NDIS, do they have a right to be able to request flexible working? Do you mean like if they've got a disability, like their NDIS is in they have a disability?
I think so. That's probably what it means. That's what I took it to mean. Yeah.
Sorry, I was going to just type the question, but I thought I would just take myself off mute. More so, which I think is becoming a little bit more topical, is neurodivergence.
Yes, that's an interesting one. I don't think there's like a general, well, I guess it's interesting because it's like, is there a diagnosed disability? I mean, potentially if it's diagnosed, I think that's a really interesting one. I have to consider that, to be frank. I don't know if there's like a genuine right, but if there is a particular diagnosis, you'd have to consider that. So I'm happy to take that on notice and have a chat to you about that because I think that's something we're going to see more of. And certainly I know in the UK they've been quite forward thinking about neurodivergence, I think more so than in Australia. Esther's nodding, you agree?
Yeah, I think so. I think you're right. It's going to become a bigger area. And also on the Westpac case, I did see that they had decided not to appeal it on Friday, which is interesting. Yeah.
Interesting.
Thanks, Amanda. And Arthur asked, do employees have to obtain approval to work overtime before they work extra hours?
That's a good question. It depends. So, you might have obligations that, like sometimes there are provisions in contracts or you have a policy around working. I think it's a good idea to think about if people are just working overtime without needing to or requesting. I guess it depends on the actual business and how you are set up. So you might, if you're having a problem where somebody is just working excessive overtime, but you don't think they need to, I think then have a conversation about it. It's a bit different if they have to work overtime and as opposed to requesting approval to. And I see that sometimes that some people like will just do the extra hours without, and then they might request to be paid or given time off in lieu, depending on if they're covered by an award and so forth. But I think do think about these things because, yeah, that can be a tricky issue if they have just worked all these hours, but they haven't been necessarily told to or have to. So having that workflow conversation is really important about whether, so yeah, I guess it depends about how you run your business, but certainly if you don't think that person needs to, they should perhaps request approval or say I need to because of X before they actually go and do that, because we're seeing, you know, a lot of cases around what is reasonable additional hours beyond, you know, if you've got a 38-hour working week, someone's working 42 hours, is that reasonable? Maybe. Are they working 55 plus, 60 plus? That might not be reasonable. So it's good to have those conversations and have some parameters around that. And just quickly before we finish, I'll be super quick, just a couple of changes on the horizon. First of all, last week, this bill has passed Parliament. So from 1 July 2026, all employers are required to pay superannuation contributions each pay cycle. Now, previously you could do it quarterly. I know that some particularly small businesses are panicking because obviously paying each pay period is a big shift. Some of you might already be doing it. Fantastic if you are. You don't need to worry about this. But make sure that you are getting ready for this, looking at your financials, making sure you can pay everyone's super at the same time as their pay cycle, every pay cycle. Because if you don't, and the funds are not received within 7 business days after payday, you may be liable to pay the superannuation guarantee charge. So just be mindful of that coming up next year. The other thing we've seen, and this has just come out in the last week, and again, you might have seen some of this chatter in the media, is this large increase in both unfair dismissal and general protections claims, bullying and sexual harassment complaints. So this data comes from the Fair Work Commission annual report, which was, I think, came out about last week or the week before. So we're seeing, as you can see across the last few financial years, a very high increase in the number of claims, particularly a huge jump over almost 60% in general protections non-dismissal applications. Now, those are applications by people who are still employed by a business, as opposed to like unfair dismissal or general protections where someone's been terminated. So a huge increase in claims as compared to 2020, 2021, and generally across the board, 24% higher than the 5-year average. So huge shift there. I think, and as a result, although this slide doesn't show it, there's also been a flow-on effect, particularly in the general protections type claims under the Fair Work Act, because there's more of them will not settle, and they'll go on to the federal court or the federal circuit, family court, and they're just saying we can't deal with the increase in claims. There's been the president of the Fair Work Commission has basically come and said that the increase in claims is unsustainable. There's been a lot of chatter around why the increase. I think there's a huge range of reasons. Economic uncertainty, a lot of redundancies we're seeing just because of the economic climate is part of it. I think people are generally more aware of their rights these days. There's been a lot more media coverage of workplace matters. I mean, there's probably not a week that goes by without some sort of workplace issue, whether it's, the Coles and Woolworths decision, the Westpac decision about the working from home. There's always something in the media. Super Retail, the CEO, affair with HR person, all these kind of things. There's a lot in the media. I think you can't go a day without seeing something. So, but also the use of AI. There's certainly more employees who are accessing AI to bring, to draft their applications. And there's a lot of, representative, both lawyers, HR, IR out there now that sort of do a no-win, no-fee arrangement, or they specialize in unfair dismissal claims, and they, and so there's sort of a multitude of factors, I think. I guess the key thing here is really if you're uncertain about, the obligations of an employee, if you're uncertain about, whether it's redundancy, performance management, managing conduct, managing employee rights, flexible work requests, payment, award coverage, classifications, payroll. There's so many things you've got to be on top of now. It's really hard to keep up as a small business owner. Seek advice. You know, you've got great advice here with the seed team for more complex legal matters. You know, we can come to us. There's a lot of people available. But I guess the point being, just don't assume or don't ask ChatGPT. I have seen some ChatGPT things go wrong where people have gone, oh, I've just checked ChatGPT and it's told me this, and don't rely on it. I mean, yes, certainly for some certain questions, but there's a lot of really good information out there too. Like the Fair Work Ombudsman site has some great information. For example, it's got a whole web page on record keeping, timesheets, employment records, roster spreadsheet templates, all these kinds of things. If you're thinking, what am I going to do about this Woolworths decision? There's heaps of stuff on there. It's all free. It's all available. So that's always a good place to start if you're unsure. But obviously seek proper advice from the seed team if you need legal advice or legal representation. It is an additional cost to your business, but certainly something that will help you in times of need. We've got time for some questions.
Any questions for Brigid while we have her? And she's not on the clock. This is awesome. I think for me, Brigid, it just shows the immense complexity of the legislation, and understanding, if you don't understand whether you do have award covered employees, getting that advice, making sure you've got your record keeping sorted, and the whole principle of reasonableness around making decisions, which is where it, certainly if you're in a standalone HR role or you don't have internal HR, just having someone else to kind of talk through options and situations and manage risk in that way. Any questions? Burning questions? Feel free to come off mute or post a question in the chat. We also have a load of free resources on our website as well. Some great infographics, one that talks about the difference between general protections and unfair dismissal, one on flexible work arrangements. So feel free to head there to get some tips. Well, if we've got no questions, thank you so much, Brigid, for sharing your expertise with us today. It was a great session. As I said, it will be recorded, and we will share that with those that registered and attended. Thank you to all of you for coming. I hope you got something out of it. Our next webinar will be next year. I think it will be someone from Seed HR, mystery guest, and we'll let you know nearer the time. But otherwise, thanks again for joining, and enjoy the rest of your day.
Thanks.
Bye.
Thank you.
Thank you.
Thank you.